Eddie.
Good morning, Your Honor. Victoria George.
Good morning, Ms. George. Good morning, Ms. Reed. Good morning, jurors. My name's Beverly Cannoni. I'm a judge of this court, and we want to give you some idea on how we think your day is going to shape up. First and foremost, we want to thank you for being here today. Our system of justice simply wouldn't work without our jurors, and we really appreciate that you're here today, ready, willing, and able to serve if called upon to do so. So you've heard that we're selecting a jury in a criminal case, Commonwealth versus Karen Reed. The Commonwealth alleges that at approximately 6 a.m. on the morning of January 29, 2022, the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road in that town. Officers responded and discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center, where he was later pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies these allegations. She is presumed to be innocent and has pled not guilty. Ms. Reed is charged with second-degree murder. She is also charged with manslaughter while operating a motor vehicle and with leaving the scene after causing personal injury or death. I will describe these crimes in detail at the end of the case when I teach you the law, but briefly, murder is the unlawful killing of a human being. There are various ways in which the Commonwealth can prove a murder case, and the Commonwealth is permitted to proceed under all theories it believes it can prove. Here, the Commonwealth alleges that the defendant committed murder and that that murder was murder in the second degree. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that she committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct. These terms and the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, at the outset, I would like to address the issue of public interest in this case and the duty of this court to adhere to the rule of law. John Adams said that we are a government of laws, not of men, and that the law must be deaf to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence at all. The law works in a different way, and the difference is crucial to our system of justice. The jurors selected for this trial will hear and judge the evidence. They will determine what the facts are, and where the evidence is contested, they will determine where the truth lies. Ultimately, the jury will decide whether the Commonwealth has carried its burden of proving that Ms. Reed is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this criminal trial will be decided by an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So while public comment will likely continue, the rule of law will be upheld. In order to determine your eligibility to serve on this case, I am going to ask you questions to all of you as a group, and then I'm going to ask you to fill out a supplemental questionnaire. We have found that the use of this questionnaire is helpful for several reasons. First, there are some personal questions on it, and we ask that you be candid. In addition, the process of filling out the questionnaire provides the opportunity to be more reflective as you answer the questions, rather than being put on the spot and asked to give immediate answers. After you fill out the questionnaire, we will have you come up to the sidebar one at a time so that we can follow up with you on your answers to the questionnaire and to my questions. I want to thank you in advance for your patience as we go through this process. As you may know, the lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or for no reason at all. Therefore, some of you will be excused during the impanelment procedure. If you're not selected for jury service on this case, please don't take it personally. It's not a reflection on you at all. You will be directed back to the jury room and perhaps be picked for a case in the district court. In a few minutes, I will pose a series of questions to you. I'm not asking you to take out your white juror cards yet. I'll let you know when you need to do that. You've taken an oath that requires you to truthfully answer the questions I ask and all questions posed to you. If your answer to any question is yes, I will ask that you raise your hand and hold the juror card up in the air so that the court officer can read off your number. The fact that you answer yes to one of my questions does not mean that you're automatically disqualified from jury service. It simply means that there are matters that the lawyers and I need to discuss with you at sidebar. If you find a question posed to the group overly intrusive, you may elect to answer that question at sidebar too. I will have additional questions for you which relate to issues that may be raised in the trial and are designed to give us information regarding your ability to serve as a fair and impartial juror, and the lawyers are permitted to ask you questions for the same reason. This is not a test. There is no right or wrong answer. We're simply looking for your most honest answer and your best answer. I'm now going to ask the lawyers to introduce themselves to you, and I'm going to ask counsel for the defense to introduce their client.
May I?
Please.
Thank you.
Good morning, ladies and gentlemen. My name is Hank Brennan. I represent the Commonwealth of Massachusetts. Along with me, I have two colleagues who would like to introduce themselves as well.
Good morning, my name is Laura McLaughlin. I'm an Assistant District Attorney in Norfolk County. I thank you for appearing today and appreciate you being here.
Good morning, my name is Adam Lau, Assistant District Attorney with the Norfolk County District Attorney's Office. Just want to thank you for your time and attention today and for me.
Thank you.
Good morning, ladies and gentlemen. My name is Alan Jackson. I have the honor and privilege of representing Ms. Karen Reed, who's standing to my right.
Good morning, ladies and gentlemen. My name is Elizabeth Little, and I also have the honor of representing.
Good morning. My name is Robert Alessi. I have the pleasure of representing Ms. Reed, and I thank all of you for your time in being here today.
Good morning, ladies and gentlemen. My name is David Unetti. I'm an attorney with offices in Boston and right here in Dedham, and it is truly my privilege to represent Karen Reed.
Good morning, everyone. My name is Victoria George, and I also have the privilege of representing the jury.
Good morning, I'm Karen Reed. Thank you for being here.
All right, thank you all. Folks, I'm going to read a very long witness list to you. I'd ask, though, that you pay close attention to it because in a little while, I'm going to ask you whether you know any of the folks or have had any prior dealings with the people whose names I read. The list is alphabetical, and it is alphabetical by first name. Aidan Kearney, who is from Jefferson, Mass. Dr. Isaac Wolf from South Miami, Florida. Alfredo Lopalato from Canton. Allison McCabe, Canton. Andre Porto, who is with the Massachusetts State Police Crime Lab. Andrew Klain from Bridgewater. Andrew Rentschler, who is a PhD from Pittsburgh, Pennsylvania. Angela Malvone from Canton. Annie Chung from Canton. Anthony Flamati, who is with the Canton Fire Department. Ashley Bell, Canton. Ashley Valere from the Mass State Police Crime Lab. Brian Albert from Norwood, Brian Albert Jr., Boston, Brian Higgins from Sandwich, Brian Loughran from Canton, Brian Wanless, who is retired from the Canton Police Department, Bridget Meehan, who is the keeper of records in Canton. Caitlin Albert, Easton, Lieutenant Charles Ray of the Canton Police Department. Chief of Police Helena Rafferty, also from the Canton Police Department. Chris Van E., who is a PhD from Novi, Michigan. Christina Hanley from the Mass State Police. Christopher Albert, Canton. Christopher Curran, Canton. Colleen Crawford with the Norfolk County District Attorney's Office. Colin Albert, Canton. Courtney Proctor, Canton. Kurt Roberts, Canton. Daniel Whitley, who is with the Canton Fire Department. Daniel Wolf, who is a PhD from Penns Park, Pennsylvania. Derek Ellington from Wake Forest, North Carolina. Dr. Marie Russell, who's from Los Angeles. Dr. Elizabeth Lopesada, who's from Providence, Rhode Island. Elizabeth Proctor, Canton. Eric Hanlon, Canton. Erin Beatty, Canton. Erin O'Keefe from West Bridgewater. Francis Walsh, Canton Fire Department. Garrett Wing, who is from Green Cove Springs, Florida. Gary Fowler, Brockton. Gregory Woodbury from the Canton Fire Department. Gretchen Voss from Boston. Hannah Knowles from the State Police Crime Lab. Heather Maxon from Walpole. Erabito Hernandez from the Boston Police Department. Holly Price from Mountain View, California. Ian Whiffen from Vienna, Virginia. Dr. Irene Scorti-Bello, who is from the Office of the Chief Medical Examiner's Office in Massachusetts. James Crosby, who's a PhD from Jacksonville, Florida. Janet Reed, Dighton. Jason Becker from the Canton Fire Department. Jean DeMoulis, Canton. Jennifer McCabe, Canton. Jessica Hyde from Bridgeport, New York. John O'Keefe, Sr., who is from Braintree. Judson Welcher, who's a PhD with a company called Aperture LLC. Julie Albert, Canton. Julie Nagel, Canton. Dr. Justin Rice from South Weymouth. There are 2 juveniles in this case who live in Canton. Their initials for the first juvenile is KF, and the initials of the second juvenile is PF. Caitlin Boudreau, Raynham. Karina Kolakithis from Canton. Katie Camarano, Canton. Katie McLaughlin from the Canton Fire Department. The keeper of records for Ring from Hawthorne, California. Kerry Curran, Canton. Kerry Roberts, Canton. Kevin Albert, Canton. Kevin O'Hara from the Massachusetts State Police. Lance Mello from the Mass State Police Crime Lab. Laura Sullivan, Pembroke. Laurie Cahill, Worcester. Leslie Pearlstein, Canton. Lieutenant Michael Lank from the Canton Police Department. Louis Jutras, Canton. Lieutenant Brian Tully from the Mass State Police. Lieutenant John Fanning from the Mass State Police. Lieutenant Paul Gallagher from the Canton Police. Maggie Gaffney from Bonita Springs, Florida. Mark Lopalato, Canton. Margaret O'Keefe from Canton. Marietta Sullivan, Pembroke. Mary Souza, Dighton. Matthew Amory, Canton. Matthew DeSogra from Charlotte, North Carolina. Matthew Erickson from Grosse Pointe Farms, Michigan. Matthew Kelly, Canton Fire Department. Matthew Kelsch from the FBI. Matthew McCabe, Canton. Maureen Harnett from the State Police Crime Lab. Megan Mariani from New York, New York. Michael Camerano, Canton. Michael Easter, Los Angeles. Michael Trotta, the Canton Public Works Department. Michael Wagner, Foxborough. Mike Maroli, Bridgewater. Mike Rushworth from Thompson Station, Tennessee. Natalie Wyweek Berschneider from San Marino, California. Nathan Reed, Raynham. Nicholas Bradford from Lorton, Virginia. Nicholas Curran from West Roxbury. Nicholas Kolakithis, Canton. Nicole Albert, Norwood. Norfolk County District Attorney Michael Morrissey. Officer Kelly Deaver from the Boston Police Department. Officer Nicholas Barrows from the Dighton Police Department. Patrick Haggerty, Somerset, Mass. Paul Makowski, Melrose. Paul O'Keefe, Canton. Rebecca Bison, Canton. Rebecca Trayers from Norfolk, Mass. Dr. Renee Stonebridge, who is also with the Office of the Chief Medical Examiner, and she works in Boston. Richard Green from St. Pete Beach, Florida. Richard Donatino from Canton. Robert Gilman, Hull. Ryan Nagel, Canton. Sarah Levinson, Canton. Sergeant Brian Gallerini from the Needham Police Department. Sergeant Sean Good from the Canton Police Department. Sergeant Paul DGM Petro from Canton Police Department, Sergeant Yuri Buchanan from the Mass State Police, Shannon Burgess from South Lake, Texas, Cheryl Waugh, Canton, Sophie Herzan from the Mass State Police Crime Lab, Stephanie Devlin, also from the Crime Lab, Stephen Mullaney, Canton Police Department, Steve Nelson, the Norfolk County DA's office, Stephen Bernstein, who is a keeper of the records in Stoughton, Stephen Ridge from the Boston Police Department, Stephen Seraph, Canton Police, Stephen Scanlon from West Roxbury, Terry Kuhn from Davis, California, Tess Chart from Lorton, Virginia, Thomas Beatty, Canton, Thomas Kelleher, Canton, Thomas Martin, Weymouth, Timothy Nuttall, who is with the Canton Fire Department, Tristan Morris, Easton. The following people are with the Massachusetts State Police: Trooper Connor Keefe, Trooper David DeChico, Trooper Evan Brent, Trooper Jeffrey Koskowski, Trooper Joseph Paul, Trooper Kathleen Prince, Trooper Michael Proctor, Trooper Nicholas Garino, Trooper Zachary Clark, Wendell Robery from Canton, and William Reed from North Dayton. So, those are a lot of names, a lot of witnesses. Again, not everyone will be called as a witness, but you will likely at least hear something about these folks or hear their names mentioned. So it's clear this is going to be a long trial. We're in the process of impaneling a jury. We don't know how much longer that's going to take. The lawyers tell me that once we actually start with the evidence, the case should take probably 6 to 8 weeks. That is a good faith estimate. We do our best to keep everything on track. At the end of every day, I will tell the jurors where we are, if we are on track, ahead of schedule, or behind schedule. And I don't remember ever having to say we were behind schedule. We do appreciate how important your time is to you, so we don't want to waste anybody's time. The schedule that we will have, every day will start at 9 o'clock. We'll take a break somewhere around 11 o'clock or so for about 15, 20 minutes. We'll break for lunch somewhere around 1 o'clock. You will have lunch brought into you, so you don't have to walk down to Dedham Center to get something. You can stay at the courthouse, and we'll probably take half an hour, 45 minutes for lunch. And the afternoon session should end at 4 o'clock. Sometimes the jurors agree to go a little bit later, maybe to finish a witness or something, but that's the schedule. There are some days sprinkled in throughout that schedule that we will either do half days or we won't be in session, and I'll let the jurors know that when we start the trial. So that's our schedule. Now, it might help if I give you a preview about some basic law that applies to criminal cases like this one. It's my job to teach the jury the law at the end of the trial, but until then, these are some very important summaries of very important constitutional rights. First and most basically, the defendant starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is simply a piece of paper. It just makes an accusation. It's a formal manner of bringing a case or bringing a person to trial in the superior court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence alone requires you to find the defendant not guilty. The law does not require a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until the jury makes their determination after listening and considering all the evidence. And that leads me to the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the government, you accuse me, now you prove it, and prove it beyond a reasonable doubt and to a moral certainty. I do not have to say a word. The question of whether a defendant is guilty or not guilty has nothing to do with whether a defendant testifies. The jury must not consider it in any way. You can't discuss it in your deliberations. The jurors in a criminal case must determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the evidence and the exhibits. That brings me to proof beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, but it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs based solely on the evidence that has been put before a jury in a case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I am sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to start making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon unsupported assumptions. Fourth, as you listen to testimony about the people involved in this case, consider them as individuals rather than as members of a particular group. Finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law, without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, I know that some of this may be confusing. Perhaps all of it's confusing at this early stage. You'll certainly be in a better position to understand this at the end of the case when you've heard all the evidence and I've given you instructions on the law in detail. So don't be worried if you didn't catch everything I said. Why am I telling you these things now? Because we need to know if you are able to follow the law in this case. You don't necessarily have to agree with the law, but all jurors will have to apply the law as I describe it to you. So, for jury selection, it's important to know if any of you might have some doubts whether you can accept and follow those legal principles that I've just talked to you about. So I'm now going to ask you several questions. If your answer is yes to any of the questions, please raise your hand. So take a minute, please, and take out your cards. Now, before we begin, I understand that sometimes jurors do not fill out the juror questionnaires completely. Sometimes we're in a hurry to get those questionnaires back in, or we might think that our situation doesn't apply to the question that's being asked. So if you know now that maybe you didn't complete the questionnaire fully, please let us know when you come to sidebar. Oftentimes, jurors might forget to fill in their employment, whether or not they've had any experience as a juror or a criminal defendant or a witness in a case. Many times you forget to put your age in. All of those things we'll ask you about if you haven't done it, but if you know now that there's something you left out, please let us know when you come to sidebar. All right. So, first question. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with any of the witnesses whose names I've said? Okay, thank you. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with the lawyers in this case or with the Norfolk County District Attorney's Office?
Juror number 921, juror number 931.
Thank you. Do any of you folks or a close personal friend or family member have any financial or other personal interest whatsoever in this case or its outcome? I see no affirmative responses. Has anyone seen, heard, or talked about this case? If so, please raise your hand.
932, 936, 923, 935, 906, 926, 928, 913, 944, 934, 954, 950, 946, 955, 940, 915, 926, and 939.
922, 951, 957, 933, 917, 904, 921, 949, 920, 938, 925, 930, 931, 941, 929, 916, 908, and 903.
All right, thank you. Have any of you folks expressed or formed any opinion with respect to this case?
936, 935, 928, 913, 944, 954, 924, 939, 915, 940, 955,
and 908.
All right, thank you. Are any of you folks aware of any bias or prejudice that you may have in regard to this case or in favor of or against either party? If so, please raise your hand.
928, 919, 913, 955, and 924.
951, 957, 933, 917, 929, 930, 916, and 908.
Thank you. Do any of you folks have any difficulty hearing or any problem with understanding the English language, any physical or mental condition, or any religious or philosophical beliefs that would interfere with your ability to listen to the evidence, to hear the evidence, to understand the evidence, to concentrate during the trial, or to deliberate for the purpose of reaching a verdict? If so, please raise your hand.
953 and 923. 926.
Okay, thank you. Do any of you folks have any difficulty following those very important constitutional rights that I explained to you earlier? First, that the burden of proof rests entirely with the Commonwealth. That burden of proof is proof beyond a reasonable doubt and to a moral certainty, and that the defendant has absolutely no burden to do anything other than attend the trial. Is there anyone that would have difficulty following those very important constitutional principles? I see no affirmative responses. I can tell you folks that after every trial I talk to the jurors, and even though they may not have been happy to have jury duty when they came in the door, they tell me that it has been an interesting experience, and many jurors tell me that it is a rewarding experience. But I understand that for some of you folks, given the schedule of this case, serving on this jury may be an undue hardship. And what do I mean by that? So an undue or a substantial hardship, it's more than mere inconvenience, because every civic right that we have, or every civic duty, causes us to be inconvenienced. It's something much greater. It's something that means it's personal to you, so I excuse you, but then somebody else has to step in and take your place. I generally think of it in terms of you have surgery or airline tickets scheduled during the course of this trial, but I will listen to anyone who thinks that serving on this jury would be a substantial hardship. If that's you, please raise your hand.
928, 913, 944, 923, 950, 953, 946, 940, and 939.
951, 933, 917, 949, 925, 919, 929, 941, 930, and 908.
Okay, thank you. So I am going to leave the bench in a minute to give you a chance to fill out those supplemental questionnaires. I ask that you not talk to any about those questionnaires. Nothing about any questions or comments or concerns you might have about jury duty, either generally or in this case in particular. If you do have any questions about your jury duty, you can ask me when you come to sidebar. So thank you very much.
All rise to the court, please.
Oh, yeah. Thank you. Okay, great.
Thank you.